7 months to 1 year, okay? If the offenses change to the older offense, then in theory the guidelines look like this. You got locked up for the PWID, right?
Mm-hmm.
How long did you have to serve for that?
Well, I did 6 months.
Okay, and you've been off probation for some time, right?
Yes.
So that would be 7, and that would be Section B. Basically, your guidelines would be a lot lower without the mandatory minimum as well. But even with them, the worksheet only recommends 7 months to a year, but because of the mandatory minimum, it has to be at least 2. Come on in.
Hi, excuse me. Hi.
Hello.
I'm Rebecca Robinson.
Hello, Rodney Wesson.
Tatem. Okay, nice to meet you, Mr. Tatem. I'll go over here. I'll see good one.
Okay. The reason I talk about the guidelines is a jury doesn't get these, but a judge does. Like I said, if we get to that point with the jury, it's not going to matter because they're going to have to give you more than this anyway. If we did a plea, that would involve sentencing discretion on behalf of the judge, meaning it wouldn't be the mandatory minimum, nor would it be an agreed sentence. That's when we start talking about what the guidelines are going to be. Because your guidelines are lower than the minimum, I tend to favor the cap. Like I said, the cap of 2 years and no mandatory time, so then the judge could give you all suspended time, he could give you anywhere up to 2 years of active time, and then there could be suspended time and probation up to 5 years. There's also the option of an agreed active incarceration of a year. Probably there would also be suspended time and probation on top of that. We haven't hashed out the details of that because that hadn't been something we've been interested in. That being said, if the suppression motion doesn't work, the jury trial is very, very risky. Because even if we generate some sympathy, it's kind of an all or nothing thing. They have to either say completely not guilty, or else you're going to get that 2 years. Because the prior convictions are easy to prove.
Would he have the choice of a jury trial versus a judge?
Yes.
Mm-hmm. And the Kales would be the judge, right?
No. It could be any of them. In fact, Kales is retired, so it's less likely to be Kales than some of the others.
Okay.
So why was he,
He was just sitting in to help out with the docket that particular day.
okay.
He still substitutes.
Okay,
So if somebody's sick, he will fill in. But he is retired, so regularly being there is not an option.
Okay.
So
But you
it'd probably
can't-
be Schwartz. Who you think it would be?
It could be any of the, it could be Kales again because he
There's
does.
3 of them, right?
There's 4. There's
4.
Melvin,
Mm-hmm.
there's Morrison, there's Sword, and then there's Hawks. And basically what we'd be looking at is the judge would have to make a finding that he knows isn't consistent with the law in order to spare him the mandatory minimum time, and I just don't see any of our judges doing that, even if they had sympathy for him. A jury, at least, they could get to the not guilty because that's, jury nullification is a thing, but banking on jury nullification when you have other options is certainly something that it's something risky. So,
What do you think of Mr. Wesson?
Well, right now I'm just soaking it all in
Okay.
brain-wise, so,
Do you understand the choices?
yeah,
So you have choice between a judge trial,
yeah.
a jury trial, or a plea agreement.
Yeah.
And then in the plea agreement, there are 2 different choices within the plea agreement. A set sentence of 1 year or a cap of 2 years, which means it can go anywhere from probation up to 2 years. And Ms. Mease is a wonderful attorney who will put out all of the mitigating information that she can, but I'll be honest, I don't trust the judges here, so I would be looking, I wouldn't look for probation. I would look for them to give you some time in the cap. But what are your thoughts on that?
my thoughts are the general wisdom is when you're considering a cap versus a set sentence, which are 2 of the options with a plea agreement. There's a cap of 2 years or a set sentence of 1 year as far as active time. A lot of times if you give a judge a cap, he'll look at it as a target. Whether that's a conscious thing or a subconscious thing, they look at it as the prosecutor thinks the case is worth about this much, so I should probably give him something close to this much. Whereas I'd be shooting for all suspended time if we were going to go with the cap. I'd be arguing that you have a life that you don't want to disrupt, that you've been making productive uses of your time, that you've been doing the right thing, and that you should get all suspended time. I guess it's iffy because then you could get 2 years. But I think that your chances are better that way than the jury trial.
Are we going to present, if we went to the jury, okay, say the suppression hearing did not work, are we going to present a strong argument in reference to the inconsistencies in the transcript?
It probably won't be what you would say, because first of all, it's going to depend on how the officers testify.
What do you mean by that? How they testify?
Because what matters, because the transcript as impeachment evidence, the transcript isn't admissible as evidence of what happened. It's evidence that their testimony is less credible, right? Okay. The inconsistencies, they're there, you know. We all saw it at the preliminary hearing. I don't feel like it's bad enough to get us to nullification, which is finding somebody not guilty despite the fact that he's got the gun right in his waistband. That's nullification. That's asking a lot of a jury.
What happened with the dash cam?
Still haven't gotten any dash cams yet. They're saying that they don't have dash cams in those particular cars, which not all the police cars in Portsmouth have them.
So are we able to find out if they indeed have it? I mean, it's a particular car.
I'm trying to get something in writing.
Well, a lot of our decision will be based upon what those cameras show.
I don't think so, because it's really more relevant to the suppression hearing. And I don't think no matter what the dash cams say, I don't think a judge is going to grant the suppression motion. I think that that's setting up something that we'd be having as a basis for appeal, at best.
Yeah, I understand that, but we definitely want to know if there is a dash cam, what does it show? Because it could add more credibility to our claim that they were inconsistent in their testimony under oath. Also, just to let you know, when we came to court, I think it was the 6th.
Yeah.
It was the 6th. We had the opportunity of speaking to DeLuca.
Okay.
Okay, and when speaking with him on camera, we actually got him to admit that he did indeed give false testimony under oath. And we had that on video.
I'm sure he didn't say those words. What did he say?
He didn't say those words, of course. But I asked him, I asked him why did he give false testimony in reference to Mr. Wesson admitting that he was a felon when he was questioned. He said, no, I didn't say that. Then I said, you did say it. The transcript points out when you were questioned, did he admit to being a felon? You said, no, he did not. He said, well, I can't discuss that. The case is still going. I continued to prompt him. I continued to prompt him for information. He ended up saying, well, I can't discuss that. He was consistent with that. Then I was about to leave. Then he stopped me. And then he would say, then I asked him one more time. I said, do you remember that night? He said, yes. I said, do you remember your partner asked us corporately, were we felons, and that Rodney Wesson told you yes. He said, yes, I do, but I can't discuss that. And we have that very clear. That adds to more inconsistency. It shows everything that they've said. On top of the inconsistencies in the transcript, it shows everything that they have said has been inconsistent.
Tell me the last bit again. What did DeLuca say at the very end?
He said, yes, I do remember.
Okay.
And what he said, yes, he remembered to, is, do you remember your partner asking us corporately, were we felons, and that we admitted to you yes? He said, yes, I do, but I cannot discuss that.
Okay. See,
that adds
this
more
is where I say that the
Would that be
the
information be
inconsistency.
permitted would that information be able to be submitted into evidence?
If he denied it, there is a possibility.
I'm sorry,
If
what?
he denied making that statement, there is a possibility
He did.
that could, but whether that would be beneficial in the long run, it would be something that
Well,
I'd
my-
have to decide based on viewing the video.
My mindset is, well, the video states exactly what I said. It shows him clear.
Yeah.
It shows us questioning.
I understand, but it's kind of the tone and the overall impression that I'd be more concerned with.
Okay.
And I guess
Well,
let's
we
say
can-
this,
we can-
let's say we prove all that. Let's say we prove their cops are lying.
Mhm.
Let's say we prove that they're targeting you.
Mhm.
Let's say we prove that they're harassing you.
Mhm.
That's not the question for the jury. The question is, did you have a gun on your person, and are you a
Have they
convicted
proven
felon?
that?
Yes,
How is that proven that?
because it was in his waistband.
No, I said, have they proven that? They said it was. How you know that's not just a whole nother lie that they would tell?
Well-
They said it was.
Convincing the jury that all three of these police officers are making it up
No,
completely.
it's two.
Well, let me ask you, did they remove the gun?
It's two
This is
officers. The
between
third
me and you.
officer, I'm sorry, what's her name?
Robinson, Rebecca Robinson.
Miss Robinson, I do apologize. You said three officers. I know of Alexander, I know of DeLuca. The third officer you'd be discussing, would that be Jackson?
I think so, yeah.
Okay. Jackson is also a part of the situation because another claim that we have is that they switched firearms in the back of the vehicle. So we also have a claim that they tampered with evidence. And in addition to the inconsistencies in the transcripts, that is easily proven, in addition to the video showing that there's more inconsistency with the testimony, we also have what we believe will be proof that they tampered with evidence in order to get even a right to arrest. And we believe we can prove that because of the seating arrangement that was agreed upon by myself when I filed a report in Internal Affairs, as well as agreed upon in the transcripts by the officers. And the ownership paperwork of those who were on the scene that had the firearms. They know where the firearms were. They were on the scene. They came to the officers and pointed out where the firearms were. And we have paperwork that's showing that they own the firearms, which means they would have to explain how, if Mr. Saunders is sitting in a particular spot and Mr. Jones is sitting in a particular spot, how his firearm that legally he owns is in where he's sitting and how his firearm is where he's sitting. It shows an inconsistency in addition to everything else that's been inconsistent.
Same question as she is. So we'll throw that in there. Say we can prove that too.
All of that.
And that
Yeah.
all three police officers are lying about the firearm being in his waistband, that it wasn't even on him, that it was somewhere else entirely. Let's say we don't have any affirmative evidence of that in mind.
Well, that's what we argue. It was based upon all these evidences we're going to bring in.
Okay,
We're gonna
hang on.
Yes, ma'am.
Say we prove all that.
Mhm.
That's a whole lot
Mhm.
for a jury to bite down on. And it's very easy for them to say, well, these officers maybe were incompetent, maybe they were making mistakes about who spoke first, who approached the car first, which gun was which. But they might still very much believe that he had a gun on him, even if the police aren't doing everything perfectly. For them to say that believe that it might have been completely fabricated, when I can't even put him on the stand to say that, that's a seriously tough sell. It could happen that the jury could believe that and find him completely not guilty, but if they say, well, we're not sure, we don't think the police acted right, but we think he still has the gun, so we'll find him guilty and give him a lesser sentence because the police didn't treat him right, they don't have that option.
I understand.
They
We
can't
understand
split the
that.
difference.
But
So
we understand. Let me prove to you I understand. What you're telling me, if everything that we have presented to you all today is argued and proven, you're telling me that it's a possibility that the jury will not acquit him of all the charges, assuming that even though lies have been told,
Right,
that these
the police
officers
are
are
completely
still
shady, sloppy,
right.
and they're wrong.
Yeah, I just wanted to make sure, I wanted to make sure that you guys understand that I understand.
Okay.
That's
Yeah.
why I wanted to finish
well,
giving
but
my summary.
one correction. I think
Yes.
it's different from there's a possibility that the jury would still find him guilty. I think it would be an enormous probability that the jury would still find him guilty.
Okay. If I understand juries and litigation correctly, I've been in a few scuffles myself. It is understood that based upon the facts and the truths that have been presented in court and that's been admissible in court, they are to, at that point, make the decision based upon that. And if that is my assumption of the report jury detail is correct, if what we've stated is argued appropriately, I think it is a very strong possibility that they will say, hey, these guys have been, they've been inconsistent in everything. How are we to believe anything they're saying when they have not proven anything they're saying? Yet we have proof that they have been inconsistent. We have proof via transcript. We have proof via video. And we have also proof via paperwork for ownership of firearms. It shows that we've been very truthful, as well as my initial internal affairs report when I first was released from incarceration. And my internal affairs report.
That's not going to be admissible.
I understand that it won't. Well, I just want to ask. I don't understand that. I stand corrected. Why wouldn't that be admissible?
Because it's a complaint made after the fact by you, and it doesn't have any bearing on what happened at the time of the offense.
And then let me add to that. The jury makes the decision. They are the fact finder in this case. But the judge decides what facts they are presented. These judges are hostile. 1/10 of what you want to get in is going to be actually let in. He's going to make right or wrong, whether or not we want this evidence to be admitted. And we can, Ms. Mease is going to argue why it's relevant. She's excellent at the technicalities of the law. But the judge is still going to make bad rulings that are going to be anti-defense. So everything that you think is going to get in is not going to get in, whether it should or shouldn't be. But I understand you're saying.
Then we will have a community showdown. If I'm understanding you correct, though we have facts that are tangible facts. We have video. We have transcript. I paid for this myself, by the way. We paid for a court reporter to be in a preliminary hearing. Without that funds being spent, the court reporter wouldn't have been there. The whole relevance of the court reporter being in attendance is to record everyone's testimony so that we would have a recording so no one can switch up. So if that type of thing is not admitted into court, if the video that shows we are talking to the exact officer, there's nothing that we Photoshop or use any video editing thing to manipulate, and it shows the actual officer, his face, his voice, all parties involved. If these things are not admissible in court, at that point I would have to argue in the public that this thing is rigged. Okay. And at that point, see, I don't know if you all completely understand.
What's going on, Mr. Wesson? You agreeing with him?
Yeah.
What I
But that shouldn't be a surprise to you, Mr. Tatum, that it's rigged.
Well, I understand. So you're admitting that it's rigged. That's what you just did. You said it should not be a surprise that it is rigged. Is that correct? That lets me know as us. She brought you in saying that you were more senior.
I'm asking you that.
So
do you think that the criminal justice system is fair to defendants?
I believe it should.
Whether it should
I believe
be,
that the
is
Constitution.
It?
I believe that the Constitution gives the responsibility to the government and the municipality
yes.
to be legitimate.
It
and
should be fair.
And
I'm asking you, is it?
I have not danced with Portsmouth.
Okay.
So therefore,
We dance with Portsmouth a lot.
Huh?
We dance with Portsmouth a lot.
My hope would be that in this situation, due to the fact, and then let me hear me out, due to the fact to our proven contributions to this particular city and community aspects, that it would be fair in reference to us. We're not asking for anyone to cheat in reference to us. We're asking for those to hear the actual merits of the case.
We're asking for the same thing.
Okay, and if we argue that, and if we push to have this evidence, they would need to explain why this evidence would not be admissible.
That's what I'm saying. Let me say something.
And the judge will. He has to make a ruling.
That's my whole thing too, because it's like, why is all this stuff set in place and things done like this when we won't be the... That shows so doggone much. We got to it all. So it's like, why even do any of that and have anything and stuff set in place to where, because I've dealt with other lawyers and stuff who on technicality stuff, and I've seen for lesser mistakes by the police cases get thrown out.
And look, Mr. Wesson, from everything that Ms. Mease has told me, you are a wonderful guy.
Yeah.
And that's why she has put in so much effort and care into your case. The whole purpose of this discussion is that you understand your options and you make the choice that you think is best. Her advice is different from what you want, but either way, it's your choice. Nobody is here forcing anything down your throat. We're putting the options on the table. You pick what you want to pick. And I know that she feels that the plea agreement is in your best interest.
Mhm.
If you feel that you have enough to go forward in the jury and you want to roll the dice, we're happy to roll with you. It's your choice as long as we discussed it and put the options forth. So, and I mean, she's not making that decision lightly. She's making that decision after, having danced with the judges in Portsmouth, so to speak.
And the juries. I
And
mean,
the
honestly,
juries.
even a good
And-
jury is going to be very, very, we're talking about, I think, a small probability of an acquittal. And it would have to be an acquittal to do better than the offers.
When we participate in the jury selection,
When
when we participate in the jury selection.
When does jury selection take place?
No, when we participate in it, meaning the Commonwealth would not be the only one responsible for selecting the juries.
When you say we, who do you mean?
Our side of the team.
You are not at the table. You do not participate in jury selection. You will be out in the hallway.
That's
Why is
fine.
that?
That's fine.
Yeah.
Well,
Because
that's
he's going to be a witness. He has to be sequestered for the whole trial.
they'll bring in 40 people. Nobody picks the 40 people except for this. And I'm telling you how jury selection works.
Mhm.
The person who picks the 40 people at the clerk's office, okay? Of those 40 people, they will put 20 in the box, so to speak, okay?
And choose
And,
that.
and of that 20, we have to get that 20 down to 12, okay? They give the Commonwealth 4 strikes, they give us 4 strikes. So 20 minus 4 is 16, minus 4 is 12, okay? Now, we will ask questions that the judge allows us to ask to try to remove people who have bias, okay? Or who have any problem why they can't give you a fair trial. Once that's done, that's how those 12 get in there.
And to give you an example, and we say that we deal with Portsmouth, and Portsmouth is not necessarily defense-friendly from the judges get to decide how many voir dire questions I ask. I
And those are the
usually
questions that she asked to determine
make
who's
the
fair, who's not fair, who has a bias or prejudice.
When I go into a jury trial, I make a big list. At least I usually try and keep it on one page, although I make it kind of condensed because I feel like one page is going to be less of a problem for the judge. I go into that, even though all of my questions are legal and okay to ask, expecting that the judge is going to cross out half of them, just for no particular good reason. I ask twice as many questions as I really need because I expect he's going to get rid of half of them for no
Right.
reason.
Exactly.
And it's not like you see in other states where they spend 2-3
Yeah.
weeks on jury selection. You're lucky if you get an hour.
Commonwealth.
An hour for a murder case for
Are you,
if they make us finish in 10
are you scared to do time?
No, not at all.
I think for the principle
Okay.
of the situation, we need to fight.
Okay,
The
well, and Mr.
reason
Tatum, hold on. I need Mr. Wesson to say, not that you aren't a wonderful representative for him, but I gotta hear it from you. What do you wanna do?
We need to fight. That's my whole thing.
What you mean,
Mr.
what?
Wesson, I just like the idea of the case being about who you are as opposed to about little things that the police are switching up on. And they are little things in the grand scheme of things. Police make much bigger mistakes and tell bigger lies, frankly, on a regular basis. We're not going to be able to put in a bunch of evidence about your character in the case in chief either, is the problem. We'll try and get in some of that, but I can't put you on the stand. If I try and put in evidence that you're just a good guy, that's liable to be objected to. And like Ms. Robinson said, I can't even...
We'll handle that.
No, you can't. But if the judge says it's not admissible and takes you off the stand...
He only has jurisdiction in the courtroom. We're beyond the courtroom. I don't know if you all paid attention to who you're actually dealing with. I'm pastor of the Oxford Ministries. I'm president of the Coalition for Justice, Chesapeake Branch, led by the great Rudy Maker.
I understand you said you're gonna take it to the community.
That's already in the making. And what I'm saying to you, my goal is to resolve this privately for the simple reason I have respect for my friend Kenny Wright. And I don't want to do anything to hurt his administration. However, once I meet with him, and I will, I intend to do so, that's already been set up in the making as well, I intend to have a conversation with him in reference to everything that we're discussing. And even by his public defender's office, which in my opinion, Ms. Mease, we may have hit it off rocky, not the first time, the second time, but that has completely turned around, in my opinion.
Well, you know, the mayor doesn't have control over this office. It's a state agency.
I understand, but you'd be surprised what can happen. Listen, like I said, this is not my first go around. This is the first time do I have to fight for one of my own, but this is not the first time I've fought for many people. I've had many people case dismissed. I've had many people sentence decreased, and I don't think that my experience and my knowledge, and as well as my years of dedication to community service, is going to fall short for someone
You can get this
that is
case
by
dismissed
myself.
without us going into court.
I don't know if I can get it
Nobody
done,
is
but I believe that.
standing in the way of that.
And I understand that, and no one will stand in the way of what we aim to do. My goal is to have a fair proceeding. You've admitted to me yourself that the judge or the
I've given you my opinion
Right,
after
and-
practicing
and-
here,
and
I
but I'm
respect
not a
that.
part, I don't contribute
But
to
you-
the
But
unfairness,
you've
I'm
also
fighting
pointed
against
out
it.
that you know that this thing is rigged. These were your words. And and if
And I
it is
mean,
rigged,
why are
that
you
is
saying, I feel like you are
inappropriate.
threatening me when you say
Whoa,
that.
whoa, 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 whoa. First of all, let me get it very clear. In any way, form, or fashion, there's no threat towards you.
Okay.
No, Ms. Mease. So we can get that out of the way.
All
What
right.
I'm saying is, it's not a threat if I'm quoting what you're saying, if I'm regurgitating what you're saying back to you. I'm saying you admitted to me as an attorney for Portsmouth that the legal system is rigged here. That is not a threat if that is your exact words.
I would then let me clarify. I don't think,
You said
I
it should
think
not,
that
it should not be a
sometimes-
surprise to me that it is rigged. Is that what you heard?
that is,
That's what
and
I
that
have.
was
That's
what you
what I
had
have.
said. You had said it was rigged first. I was using your word.
That's
I'm
right.
saying that it's, the fairness that you think you will get is
Mhm.
not always there.
Okay.
So as long as you understand that,
You
it's
s-
fine.
But in turn.
Do you
I
understand
said-
that, Mr. Wesson?
In turn, I stated that if the information is not admitted into court, then it is rigged. You said it should not be a surprise to you, Mr. Tatum, that it is rigged. That's a little difference between what I said and you said. That's not a threat. That's simply pointing out what was said.
Okay.
And I'm a stickler on making sure that I hear what people say, and I'm a stickler on making sure that I say the appropriate thing that's really in my heart. I've trained, I've practiced in mirrors, I've made sure I don't speak out of turn. And I know what was said, and I will present what is said in whatever arena I need to, because if anybody knows anything about us, we record, we video, we do all sorts of things to make sure that, because we know that people are not just going to take our word for it. We know the Commonwealth says that we are felons, so, and then who wants to take the word of a felon? So, but it's hard to refute our word when we're using your own word and your own voice against you.
But that's where the threat
Let me
comes in.
just.
Why are you,
let's-
I'm here to help. Why
I
are you using
want-
things
I
against
want
me?
you- I want your help. No. Listen, okay, let me, I see exactly what you're saying. I see exactly what you're saying. But please listen to me with your heart and your mind, okay? I am not in any way against you or you. This is what you must understand. I am for him. You've got to understand that. I am not against you nor you. Neither one of you, no matter how this turns out, neither one of you are facing time of probation. This brother is so valuable to myself as well as to the community.
And
that
to
you must,
us.
that-
We are
that-
here-
but
everybody here
have
is for you, Mr.
You have
Wesson.
no understanding. I understand, but he is a client to you. He is a family member to me. He is a part of a program that stands for holding municipalities to what the Constitution says they should stand to. This is what we do. So this is the first time, and you must understand this, that we've ever had to do this in reference to one of our own. Usually it has to do with people from the community. So I'm going to, and if I fought with everything I had for them, who were not, they were clients to me, but I'm a pastor, so it's a little different. But you have to understand the intimacy level.